Hello, and welcome back to At Your Pace Online's Michigan Real Estate Education Series. The focus of this segment will be contracts and contract law. We'll start by covering the fundamental concepts, including the legal guidelines of contract formation and the basic categories of contracts. Then, we'll talk about the core elements of contracts. In this first portion, we'll mainly address contract formation, but we will also look at performance and interference, as well as breach of contract. Next, we will discuss contract considerations, such as clauses, assignment, and dispute resolution. We will then shift to explore the unique elements of real estate contracts. And finally, to end the class, we will talk about the Michigan rules and regulations affecting contracts. A contract can be simply defined as a binding agreement between two or more parties. It is a formal statement of what's been agreed upon by the parties to the contract. It creates a legal obligation for each side to perform certain acts or behave in a specific manner. When we talk about core elements of contract law, we are referring to categories of court rulings that cover specific topics. These rulings set forth specific elements required for a contract to be valid and enforceable. The four basic elements of contract law are formation, performance, breach, and remedies. Before a contract can exist, it must meet specific requirements. By meeting these requirements, the contract will be considered formed, or legally binding. With respect to formation, there are 5 elements required to form a legally binding contract. First, the parties to the contract must be legally able to enter a contract. Then, an offer must be made. The offer must be mutually accepted. The contract must have a legal purpose, and consideration must be clearly spelled out. Once there is a contract that meets the requirements of formation, the parties can proceed. In the real estate industry, the process generally begins with an offer. This is followed by negotiation with the potential for multiple counter offers, and then mutual acceptance and acknowledgement of the offer. With acceptance, a formal agreement is established in the form of a contract for sale. This is known as the purchase agreement. Contracts may be formed between any number of parties. However, in real estate transactions, there are generally only 2 parties, the buyer and the seller. In this class, we will discuss all contracts as if they only have 2 parties. You should bear in mind, though, that all of these facts apply regardless of the number of parties to a contract. The 3 remaining core elements govern how the parties proceed. Remember, those are performance, breach, remedies. Performance refers to the obligations of the various parties to the contract. In a real estate contract, the seller performs when title of the property is transferred to the buyer. The buyer performs when they transfer money to the seller. However, performance can relate to any contingencies or clauses which the parties choose to include. This might refer to things like a seller's obligation to repair the roof of a home within a certain period of time, or a buyer's obligation to provide proof of financial stability. If any of the parties to a contract fail to follow through on their performance of the obligations under the contract, they will then be in breach of contract. If the other party has been damaged by the breach, the law provides remedies that the damaged party can use to obtain the benefits bargained for in the contract. Like math, you'll work with contracts a lot. The real estate industry runs on them. Contracts are the basis of the agency relationships between brokers and clients, and brokers and salespersons. As a salesperson, you won't be signing contracts directly with members of the public. However, you'll probably help form these kinds of contracts, and you'll be helping clients negotiate the contract for sale or purchase of a property. We will begin by defining core terms. Let's get started.